Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we will be continuing with your interpretation of statute, deeds and documents. Right? We've already had a couple of lectures on this topic. We have been through the basics. We have seen two rules of interpretation, that is the literal interpretation and the reasonable construction. Right? Today we move on to the third step, right? That is the third rule of the primary interpretation, which is the rules of harmonious construction. Right? I've already given you the basic of what this rule is in the very first class when we were discussing the rules, right? The basic division between the primary and the secondary rules. Remember that? Okay. So I think and I hope that the previous lectures were useful for you, right? And you know very well what literal construction and harmonious construction, the reasonable construction is, right? And I'll try my best to explain it very clearly as to what harmonious construction is, right? And along with this lecture we will also share one or two questions that have been asked in your previous examination. It will help you to understand what are the kinds of questions asked and how do you actually have to look at the topic. What is the angle with which you will understand and you will memorize the topic, right? Because that is basically the main problem that students face in the CA final. You know everything that, okay, you know that I know everything about this section, but there's an angle through which you have seen. But when the question is asked, it is asked about one specific topic, right? It gives you an example, it gives you a case study, and you're not able to link. Why? Because although you know the entire text, but you have not gone beyond. You do not understand the essence of it, right? So linking becomes a task at that point of time. So that is why after completing this description about the harmonious construction, we will also go through two questions about what harmonious construction is and how is the question being put forward to you in the examination, right? And for that we'll be discussing the two questions in the examination as well, right? So the rule of harmonious construction, if you remember, then I told you in the initial class, right, that what is harmonious construction? Harmonizing thing, right? There are few provisions, like 2-3 different sections, maybe talking about the same thing but with different bandwidth, different parameters, and they are all generalizing it. What you need to do is you need to see what is the midway out. That means how can you apply the provision so that both your purpose is solved. When I talk about both the purpose, yes, one is that the first provision that you were directly dealing with is solved, and the second is that subsequent provision is also solved. That means the purpose of both the provisions are met at the same time, right? You will have to follow a path, an action, right, that will fulfill both or all the provisions that are applicable on it, right? I'll give you the example, I'll share it accordingly, right, as we progress with the lecture. So as we have started all the other topics, we'll also start harmonious construction with its applicability, right? So first we need to understand, when does the harmonious construction rule come into play? Okay. What is the situation that will give rise to a conclusion that yes, you have to apply the rules of harmonious construction, right? How do you know? When do you understand, or when do you initiate this rule, right? So that is applicability. So when there is conflict between two or more provision, exactly what I just said, right? That if there is a conflict between two or more provision of the act, right, then you will have to find a midway out, right, that will fulfill the needs and requirements of both the provisions at the same time. So that is one particular action that you take and you fulfill the needs of both the provisions, right? And that conflict must be real and it should be apparent. That means when you read the text, you understand that yes, the conflict is apparent. For example, one penalty gives you a limit in one scene that okay, you have a limit of 2 lakhs, that is a maximum penalty. Other says 1 lakh, right? So if you charge a penalty of 50,000 to that person, that suffice both the limits. It is below 1 lakh and it is below 2 lakhs, right? I'm just giving you a simple example, right? There is a very rare situation that you have some penalties like that, right? But there are other provisions that do conflict. We'll take the examples also, right? But what you need to understand, that is why I have taken a simple example, that yes, if you select 50,000 penalty at this point of time, right, if the court gives you a penalty of 50,000, then you suffice with both the provisions. It is below 1 lakh and it is below 2 lakhs. So if it says it has to be a minimum of 1 lakh and maximum of 2 lakh, anything between 1 and 2 lakh, right? That is harmonious construction. That your action of levying a penalty of somewhere around 1.5 lakh would suffice the need of greater than 1 lakh, as well as at the same time it would suffice the need of less than rupees 2 lakhs. Are you clear with it? Now do you understand what we actually mean when we say we need to harmonize the conflict? Right? The rule of harmonious interpretation. Okay? We'll also deal with the logics, right? But as per our structure, the logic is in the second slide. If I show it to you, yeah, here we have the logic. So we'll come back to that also. First, we understood the applicability. It is only when there is a conflict. Otherwise, if you are reading a single provision, then rule of harmonious construction will never be applicable. It is only applicable to solve the conflict between two or more rules. Okay with that? So after the applicability, what do we see? We see the key features, and that is exactly what we have already discussed, right? The key features, number one is that the act is to be taken as a whole, and number two, that various provisions on the same subject matter needs to be reconciled. Now when we say that the act must be taken as a whole, then you understand, right, what is the purpose of creating an act? What is the purpose of the enactment of an act by the legislature, by the parliament? Right? Because there is a definite section, a definite genre, right, for which they want to bring out the entire law, right? And if we take an example, we will take the best example of the Companies Act. So all the provisions that have, all the sections that have been incorporated into the Companies Act relates to the companies, right? The formation of the company, the structure of the company, the board meetings, the directors, the other committees, the members, all the legal provisions, registrar, DIN, blah 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 and blah blah, up to the winding up and everything. All these things are contained in one act, right? So when you go on with specific tasks, right, for example, you're dealing with directors and their responsibilities, then you have sections on that. And then again you are dealing with some other things like, for example, intercorporate loans, investments and a lot of things. Again you have a separate section for that, right? A separate set of sections for that. Now if the two coincide, that means now that loan or whatever advance that you want to make, that will be made by the directors. So a section from director and a section from this genre about the investment and loan, they'll coincide, right? Because you have different genres, different sections for each of them, and now there is a common applicability. They have to coincide, right? And the section that relates to the directors, right, they will say something else, and on the other hand, the section that relates to the investment, they will talk about something else. And now you will have to find out a middle way, a route that will harmonize the situation, right? Because the act has to be read as a whole. If I ask you about loans and investment, you will not just refer to the sections of loans and investment, right? If the directors are making it, you will also refer to the powers of the directors. You will also refer to other provisions. Whatever provisions from any direction can be applicable, you will have to take it into consideration. You will not say, no, this section says this, I have followed it, I don't care about the other section. No, it is the same act, it has the same applicability. So you can't just take up one and avoid the other. You'll have to use both of them, and if they conflict, you will have to harmonize them, right? Whenever you pick up an act, you first divide the act and see what are the various sections, what are the various fields about which the act is talking, right? You get the overall idea. Okay, this act is based on this topic, right? These are the various regions that the act has covered. These are the various interpretations. These are the various sections, right? Then you move out with section by section, clause by clause, or word by word interpretation of the statute, of the act, right? And why do you first have to see it on the whole? Because whenever you come across a section and you need an interpretation, you should have in mind that, okay, there is one more genre that relates to this. That means there is one more or two more sections that are related. So you go back, you look, you find out what are the other sections applicable in the same place. Pick that up, read that section and read this section, and then you'll have to harmonize. Okay, so if I combine both, because both are applicable, what do I get? Okay, so this is what I get, right? And these rules of interpretation are basically required because the legislature, when they frame the statute, right, they cannot be perfect with it. That, okay, if they are referring to some other place, then they'll always also make a reference, okay, there we have set this limit, there we have given this power, so let us keep it exactly the same. No, right? And that is also true because they can be different situations. And maybe while harmonizing, you may have to give a more weightage to someone else. Like if I talk about the same penalty, right, then it has to be above 1 lakh and below 2 lakh. You can have an entire range between 1 to 2 lakh. So you may think of levying a penalty close to 1 lakh or close to 2 lakh, depending upon the situation. Whom are you trying to give more weightage? If it says it has to be below 2 lakhs, right, and it's gross negligence, then you'll have to go close to 2 lakhs or 2 lakh exactly, right? Even that is above 1 lakh. But to suffice the provision of 1 lakh, even 1 lakh or 1,10,000 would have been enough, right? So you have to see which section is more prominent, which section you have to give more weightage, right? That is what we say when we talk about the entire act to be taken as a whole, right? You cannot miss out the provision, right? Because the entire act has the same level of applicability, unless and until it specifically says that yes, this section will not be applicable on the spot, right? Unless the statute specifically declares that, you will take the act on the whole and always consider all the provisions that are related to that particular topic that you have taken under consideration, right? Okay. Next, you have various provisions on the same subject matter needs to be reconciled. Same thing that we have just discussed. If there are 2 or more subjects, or if there are 2 or more provisions on the same subject matter, then you will have to find a midway out of it. If there is inconsistency, then you will have to minimize that inconsistency, right? It may be either within the sections or between different sections of the statute, whatever it is, you will have to avoid the inconsistency, right? So that is where you play the part of, or you play the role of the legislature to minimize the inconsistency. But that is during the applicability, right? You do not amend the rule on the whole. You just see how will it be applicable on you. And for that, the rules of harmonious construction will help you out. And even that is a legal rule, right? But that nowhere amends the statute or takes the position of the legislature. It's just the interpretation, right? Okay with it? Yeah, I know we are going a bit detail into it, but you need to understand, right, what are the various aspects, what are the various sets that you have to consider. Okay, moving on. Next, you have the steps. Now this is an important consideration for you to understand, right? When we talk about the steps, how do you actually harmonize? We have been talking along that yes, you need to harmonize, you have to find out a midway, you have to avoid conflict, you have to avoid the inconsistency. Okay, I understand we have to do it, but how? That is the question, right? If I ask you to harmonize 2 provisions, even you'll ask me the same thing, sir, how? Right? We know the rule, harmonize. How do we harmonize, right? So the steps are given for that how. How do you harmonize, right? And the steps that have been brought forward, that has been brought forward by the court, the Supreme Court specifically, right? And if I talk about the specific case, that was about the Sultana Begum and the Prem Chand Jain, right? So what did the court say over there? First thing is harmonize the provision. So in harmonizing the provision, what are the steps? So Supreme Court said that if you have 2 conflicting provisions, right, or they appear to be conflicting because they do not say the same thing, exactly the same thing. And why will they not say the same thing? Because they have been enacted or they have been put into different genres. Director is a different genre, investment is a different genre, shareholder is a different genre, other committees are a different genre. Understand? Definitions are a different genre. So these are all different genres. So since they lie into different genres, so they have been mended or they have been formulated according to the genre in which they are, right? And then you have to pick up sections from other genre as well, and then you have to combine and you have to harmonize them, right? So the first step that the Supreme Court said is that if there are 2 provisions that coincide each other, that bang each other head on, right? Okay, you say this, I say this, we are different. Then you have to find out a harmonious interpretation out of it, right? You have to avoid that head on clash. As close as possible, find out a mid route, right? But if it is not very clear and it is not very much possible for you to find out a midway rule, right? Because 2 sections are talking on different tangents. How do you make that tangent meet, right? If they're approaching the direction, they'll meet somewhere, and where they're meeting, you have that harmonious situation, right? But if the tangent do not meet, what do? So if they do not meet, then you have to draw a third tangent touching both the tangent that will be applicable, and that would suffice with the needs of both, right? That none of them are destructed, or none of the provision overrule the other. Get a situation that, okay, if you apply this, then you are talking about provision number 1 as well, and you are also following provision number 2, right? Although they are not matching anywhere, right? But your action, your entire set of actions, that would ultimately suffice the needs of both the provisions, right? And that has to be drafted so that one provision should not overrule the other. You should not say that, okay, this provision is powerful, I'll apply this, and the other go to hell, we don't need you. No, you cannot do that, right? Unless it is impossible to harmonize them, right, or give effect to all the provision, what you do is that you try to reduce the differences as much as possible, right? And if you some way find out a way that one provision is fulfilled but the other is reduced to the dead letters, then that is not harmonious construction. You say that, okay, with this interpretation, the other goes to a dead letter, we don't care about it, but this provision is 100% fulfilled. That is not harmonious construction. Harmonious needs to see to the needs of all the provisions equally, right? Unless and until it is impossible. Now, what do you do when it is impossible? When you don't find a way? Listen, there is no strict rule that how do you find that way, right? When you know two provisions, you know that, okay, above 1 lakh, below 2 lakh, it is anywhere in between, yeah, do whatever you want to do. But if it is impossible, if it says below 1 lakh and above 2 lakh, what do? Right, that is the challenge. Above 1 and below 2, the bracket situation is not a challenge, right? But when they are moving in two different directions and they do not start from the common point, then it's a challenge. If it was below 1 lakh and above 1 lakh, set it at 1 lakh. That is the easiest task to do. But below 1 lakh, above 2 lakhs, what do? Right? So in that situation, you have to apply that section which is more specific to the situation, right? What happens is you have generalized things. When you talk about director's power, you have a general power, right? But again, when you talk about a specific thing in that power, but you have a different section to that, and the different section relating to that specific thing is a specific section, whereas the section in the power of the director is a general section. So in that you will see which is the more specific section, and you apply the more specific section. You avoid the general section, the general provision. And even if that is not possible for you, then just look at which section was enacted or amended later, right? But yeah, if the entire act is enacted at the same time and all the sections are there at the time of enactment, then you have a common point. Then you have to see with the general and the specific bifurcation, right? But if, for example, one section that coincides over here was later on amended, so whichever was amended later, right, that is the latest discussion or the latest decision of the legislature. So you abide by that. Forget about what was old. When they came up with a new thing, they said, okay, over here we are applying this, and that is the latest thing they have discovered. And they have discovered the need of it. That is why they have amended it. So you have to give more weightage to that, right? So that is how you take it forward. If it is very simple, go with it. If it is not very simple, there are two different tangents that do not meet, please find out a midway that will suffice the needs of both of them, right? Maybe you have a long drawn provision, long drawn step that you have taken. At one end it is touching this, and the other end it is touching the other one. So both are fulfilled, right? And if it is impossible to fulfill it, if it is impossible to intersect both of them, then what you do is you see which one was enacted later. If both were enacted at the same time, then which is more specific and the other which is more general, and apply the more specific provision. Clear with it? Right? So now I hope it is clear how do we go ahead with the harmonious construction. I don't think you should have a problem with that. Right? Now is the time to discuss the logic. What is the logic behind harmonious construction? Why do we have to go ahead with harmonious construction? If we are dealing with the loan situation and in the loan we have a section, apply it. If we are dealing with the powers of director and we have a conflict over there, then apply the powers of director. Why do we need to harmonize? You need to. You definitely need to. Why? Because when the act is enacted or when the statute is passed, it is passed on as a whole. Right? It has one general purpose for which it is enacted. The legislature, they found a need that okay, at this position or at this section or over here in this field we need an act, right? It is going without an act and it is very difficult to control. So what do? They draft a statute for that. And when they draft a statute, they draft a statute on the whole. They divide it into genre to make it easier for us to understand and interpret and to look for it. Otherwise, for every single thing you cannot read the entire act, right? That is why it is divided into sections, subsections, clauses, words and everything, parts in situations, right? So that is very much important. So although they have divided it that way, but they have divided it, understand, that is for the purpose of convenience, right, of the users of that statute, of the readers of that statute, of the interpreters of that statute. But that is not, that does not mean that the statute is divided, right? The statute has a common purpose on the whole. It has to meet the common objective. So they say that you have to adopt an interpretation which is consistent with all the provisions of the act. It may be assumed 3-4 times at different sections, so you have to abide by all of it. So follow an interpretation that is overall trying to achieve the objective of the statute, because if it is doing that, it will definitely meet the objective of the individual sections or the individual parts, right? And another thing, very important thing said over here, is that it should not be assumed that the parliament has given something which on one hand, with one hand, and took it back from the other. It means okay, they are giving you a provision, they are giving you a liberty, they are giving you an option to adopt it, and on the other section they say we do not give an option, it's a compulsion, right? So they cannot coincide with their own sayings, right? They say okay, we award you this, and then they say we take it back. It's not allowed. They say okay, the directors are given this power, and the other way they say no, directors will not do it, shareholders will do it. Then why did you give that power to the director on the first case? Go and amend that section, right? That is already done. So if there is any such contradiction over there, that one place they have given power to somebody else and the other place somebody else, and that cannot be harmonized, either they have amended it later or they have issued a notification for that okay, if there is a conflict over here, we would interpret it in this way. So even that is one way possible. But in that case where you have a notification, you do not need to apply the rule of harmonious construction, right? You will directly follow that interpretation or that notification that has come up, and your purpose is solved, right? That is the simplest thing that you can get. If you can get a notification on that topic, that is the simplest thing that you could have earned at that point of time, right? And the last thing you have is the non-applicability. When will this rule not apply? So whenever you have a non-applicability, one thing you have to make sure that this is not applicable if you do not come to this. That means the rule of literal interpretation succeeds. If your purpose is solved over there, because that is the primary rule and that is the first rule, and you always have to apply that rule. But if you are not able to interpret it using that rule, that is when you move on to the other rules, right? In the first place, if that rule suffice your needs, you will not go to any other rule. So all the other rules, non-applicability, first point stands, this one. But if the rule of literal interpretation succeeds in achieving the interpretation, then this rule will not be applicable. That is the secret number 2 in this chapter. Whenever you write about a rule, write about the non-applicability. If literal interpretation succeeds, this rule will not be applicable. As simple as that, right? But even in that rule of literal interpretation, you have to understand that you are dealing with two provisions. If your literal interpretation of both the provisions give you a common path through it, it is well and good. But if there is a conflict, you come over here, right? You come to this provision only when there is a conflict. Now even in the case of conflict, when you have come over here and still if it is not applicable, then what is the situation, right? Then you see is that if one section, right, or the statute says that one section has an overriding effect, when it uses the word notwithstanding, right, that notwithstanding anything contained in the Companies Act 1956 or 2013, this rule will apply. If any section says like that, then you have no reason to apply the rule of reasonable construction, because the other provision is already overruled. This will prevail no matter what, right? And this word, right, notwithstanding anything, this has a power to reduce the other provisions to null and void. It will have no effect at all. I don't care whatever is written, right? Because notwithstanding anything over there, anything, this rule will be applicable as it is. This section will be applicable as it is, as what is given over here, right? That is one non-applicability. Clear with it? So that was all about the rule of harmonious construction. Right? Yeah, I told you, I remember that we'll be discussing 2 questions, but again, discussing 2 questions will take some time, like 15-20 minutes, like 15 minutes at least. Right? And if I take more 15 minutes, the lecture extends a lot. So what we do is we will move on to the next lecture, right? Over there, we'll discuss an example as well as 2-3 questions on the same topic, right? And that will make things clear for you. Is that fair enough? Right? Take a break for that time, move on to the next lecture, and find me over there. So until that class, this is Abhinay Gupta signing off. Stay tuned and do the answers well. Right? Thank you and bye-bye.